Court will call 20 CR 1358, People versus Letecia Stout. Record should reflect the jury, or the jurors are present in the courtroom. Good morning, ladies and gentlemen. My name is Greg Warner. I'm a district court judge for the 4th Judicial District. Before we begin the jury selection process, I'd like to introduce you to some of the people who are in the courtroom. The case we are about to try is a criminal case. The prosecution is brought in the name of the people of the state of Colorado. The prosecution in this trial is represented by Michael Allen, Dave Young, and Angelina Gratiano, who are lawyers with the district attorney's office. If you would stand and
Morning.
I will sometimes refer to the district attorney as the prosecution or the people. The defendant or the accused in this case is Letecia Stout, and she is being represented by Josh Tellini and Will Cook. The charge against the defendant is contained in what is called the information and complaint. An information and complaint simply describes the charge made by the prosecution against the defendant. It is not evidence of anything. In this case, Ms. Stout is charged with murder in the first degree, child abuse resulting in death, tampering with the deceased human body, and tampering with physical evidence. To these charges, Ms. Stout has pled not guilty by reason of insanity. Therefore, the prosecution has the burden of proving the charges beyond a reasonable doubt. The jury will decide whether the prosecution has proven beyond a reasonable doubt that the defendant has done the things that are contained in the information and complaint. In this case, as in all cases in Colorado, the jury will be only determining the facts in the case. They will not be determining the punishment or sentence. This is not a death penalty case where a jury has to determine whether that should be imposed. This is just a case where the jury is determining the facts of the case and whether or not the prosecution has proven everything that they're required to prove beyond a reasonable doubt. Okay. At this point in time, I'm going to have the attorneys give you a 2-minute mini opening statement. It's just an opportunity for them to tell you what they think the issues in the case are. It's not necessarily what you'll find them to be if you're selected to serve as jurors in this case, but it does give us a starting point for a conversation. With that, prosecution.
Morning. January 27th, 2020. Dan Stout, 11-year-old boy, was taken, brutally murdered. The evidence in this case will show that the person who murdered Gannon Stout is the defendant seated over here to my right. And when you look at the evidence in this case, you have to evaluate it as to what's going through her mind at the time that she's killing Gannon. And the way you do that is look at her actions and what her actions were. What her actions were, stabbed him times. Gannon was fighting for his life. He had his arms up. He's got cuts on his hands, cuts on his arms. He's got 3 stab wounds to the chest. Got a stab wound to his head. Actions. He also took a blunt force object and crushed his skull. Fractured his skull. Actions. Then she took a gun. She had to get the gun. She fired that gun 3 times. One of them striking him in the chin, causing his death. But it's not only during the commission of the crime that the evidence is going to show that not only did she participate and do this crime, but she was legally sane at the time when she did it. Because she did actions afterwards. When she fired the gun, 3 shell casings come out. Those shell casings are never found because she took the time to pick them up. Not only did she take the time to pick up those shell casings, she took up the time to clean up the mess she made because he was killed in his own bedroom. And there was blood all over the wall. There was blood all over the mattress and blood on the floor. And she took the time and effort to clean that up so that she hopefully would not get caught.
Wrap up, please.
She also gave numerous versions of what happened to Gannon on January 27th, 2020. The first one was that he just went to a friend's house and ran away. She changed her story depending on what evidence was presented to her. At the conclusion of this case, you'll see that her actions led her to the charges, and we will be asking you to convict her of every charge that she's charged with, and we will be asking you to find her legally sane at the time that she killed Gannon Stout. Thank you very much.
Thank you. Defense?
What? All the things Mr. Young just told you, we're going to hear. A horrific, violent event, a brutal homicide. You're going to hear that Ms. Stout afterwards gave numerous versions, stories. Afterwards, each growing in, each becoming more irrational, as she told. You'll also hear that the evidence circumstantially will clearly indicate that after this 11-year-old boy was killed, that he was stuffed in a suitcase, transported to Florida, discarded there, and left for over a month until his body was found. You're going to hear and see photos from the autopsy of that boy who had been brutally murdered and that was in a state of decomposition. We'll also hear, though, from Dr. Dorothy Lewis, examined Ms. Stout for over the course of 3 days and 14 hours, who's from Yale, who's had 40 years of experience dealing with this, that based upon her interviews and her review of the mental health history that Ms. Stout has had, that she, among other things, suffered from dissociative identity disorder, formerly known as multiple personality disorder, that when this event took place, she was in a psychotic state and detached from reality, and in the opinion of Dr. Lewis, was insane. Thank you.
All right. Thank you. You've heard the attorneys tell you a little bit about what they believe the facts in this case are and what the evidence will show. Please understand that nothing that the attorneys say at any point in time is evidence. What is evidence is when a witness comes in, raises their hand, swears to tell the truth, takes that seat and tells you what they have to say. And then there are rules of law and evidence that apply to their testimony as well. The attorneys never take that oath. They are paid advocates in hoping to convince the jury of a particular position. So nothing they say is evidence and is entitled to any evidentiary weight. In this case, you will be asked to render a decision based on the evidence presented in this courtroom and the instructions that I give you. Even if you have heard or read something in the media, the real question is whether you can put that aside and decide this case based on the evidence you hear in the courtroom. All right, now I want to talk a little bit about the process and the law that applies to this case before I move into a different area. Every person charged with a crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless, after considering all the evidence, you are then convinced that the defendant is guilty beyond a reasonable doubt. The burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all of the elements necessary to constitute the crime charged. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence or lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that each and every element has been proven beyond a reasonable doubt, you will find the defendant guilty. If you find from the evidence that the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you will find the defendant not guilty. You may have to decide what testimony to believe. You should carefully consider all the testimony given and the circumstances under which each witness has testified. Consider each witness's knowledge, motive, state of mind, demeanor, and manner while testifying on the witness stand. And, depending on how you view the testimony, you may believe all of the testimony of a witness or part of it or none of it. A few minutes ago, you heard me tell you that the defendant was presumed to be innocent. This means that if I were to give you a verdict form right now and ask you to fill it out, the law would require that you find the defendant not guilty. That's because you've not heard any evidence in this case and the defendant is presumed innocent. That won't change or hasn't changed simply because the attorneys have told you what they believe the evidence in the case will show. Now, someone may ask you whether or not you think the defendant has done something wrong or else she wouldn't be here. However, that's an improper question. We don't just randomly select people from the street to suddenly appear in a courtroom as a defendant in a case. Obviously, there is a process in place which resulted in the filing of charges against the defendant. However, the charges against the defendant are not evidence either. The charges against the defendant are just accusations. The fact that the defendant has been accused is not evidence that the defendant committed any crime. As such, the defendant is presumed to be innocent, and until the district attorney presents sufficient evidence to overcome that presumption beyond a reasonable doubt, you must continue to presume the defendant is innocent. Stated differently, unless and until the prosecution presents sufficient evidence to overcome the presumption of innocence beyond a reasonable doubt, Ms. Stauch's guilt has not been proven. That's what the presumption of innocence means. You may find it helpful to think of the charges in this case as similar to a recipe from a cookbook. When we get to the end, there'll be charges, and each one of those charges has certain elements. And the prosecution must prove each one of those elements beyond a reasonable doubt. Now, for instance, suppose for a moment that you wanted to have a Denver omelet, and you took some eggs and you scrambled them up. You added some ham, you added some mushrooms, you added some cheese. In that event, you might have a really nice ham and cheese omelet, but you wouldn't have a Denver omelet. If the prosecution charges the defendant with a Denver omelet, the prosecution has to prove a Denver omelet. No substitutions on the menu are allowed. Proving ham and cheese omelet isn't enough. They have to prove beyond a reasonable doubt what they have charged and not something else. I also want to talk about the defendant's right to remain silent for a moment. Someone may ask you whether or not you think you would need to hear from both sides in order to be fair. Everyone wants to be fair, right? And you can only do that if you hear both sides, right? But that's an improper question, because that's not the process that we follow in a court of law. This isn't the Maury Povich or Jerry Springer show. The government brought these charges against an individual. Because of that, the government has the burden of proving the charges beyond a reasonable doubt. The defendant has no obligation to disprove the government's case. The defendant does not have to present any evidence or any testimony. In addition, every defendant has a constitutional right not to testify. The decision not to testify cannot be used as an inference of guilt and cannot prejudice the defendant. That's because it isn't evidence. It does not prove anything and must not be considered for any purpose. Sometimes you will hear attorneys ask jurors questions that are intended to elicit a response from you, such as, well, I know if I were accused of something, I would make sure that I took the stand and told my side of the story. That's probably a pretty natural response from everybody. I get that a lot from jurors. But as I indicated earlier, that's kind of a trick question because that's not the process we follow in a court proceeding. In any event, does anyone know what the number one psychological fear in the population is? It's higher than a fear of dying, and most people find it even scarier than meeting up with a rattlesnake. Yep, public speaking. The bottom line is that it is possible that the defendant won't testify, and it's possible that the defendant will testify. But regardless of who testifies and who doesn't, the question is always the same. And that is, based on the evidence that has been presented, whatever that evidence is, has the prosecution proven beyond a reasonable doubt that the defendant is guilty of the crime charged? Every physical act must be accompanied by a culpable mental state. And that's actually the language that it uses. And the reason for that is people can do things and certain actions happen, but you're not always held responsible for that unless some other mental state was going on. Oftentimes, the easiest thing to deal with are tickets because that just requires a certain act. You're going 65 in a 50. We don't care whether you meant to do it. We don't care whether you knew you were doing it. Those sorts of things. The sheer act of doing 65 in a 50 is enough. In other cases, criminal law is designed to modify behavior. And if you don't know that you're doing something, or you have a condition that is occurring such that you don't understand exactly what's going on, ultimately, the law takes the position that it is not proper to hold somebody responsible for an act that maybe they didn't know that they were doing or that they didn't intend to do under the circumstances. And then I'll get to the insanity part, which is a little bit different, because the insanity part is that there was, and I have the instructions, and if you're selected to serve as a juror, you'll get those, but the insanity part is intended to have the jury closely examine the mental state of the person at the time the crime was committed, because each act has to be accompanied by a culpable mental state. And the prosecution has the burden of proving both of those beyond a reasonable doubt. So in an insanity plea, what the jury focuses on is the culpable mental state issue and whether or not there was that mental state that is associated with that crime. It could be, in Colorado, there's a number of different ones. There's intentional, there's knowingly, there's reckless, and that's pretty much it. So, but all of those have different, very specific definitions. And so the question is, was something going on such that they couldn't form a particular mental state? The prosecution always has to prove everything beyond a reasonable doubt. The prosecution also will have to prove essentially that she was sane at the time. They have to prove that she was sane. The prosecution will always have to prove everything. So they're going to have to prove that this crime occurred. They're going to have to prove that it occurred in a specific way. They'll have to show a manner of death. They'll have to show all of those kinds of things. They will have to show that it was this defendant and not somebody else that did it, or somebody unknown that did it. So they'll have to tie it to this defendant. In the law, the position that is taken in the law is that if you have this mental state, so you either knew what you were doing or you intended to do what you did, and that caused you to act in a certain way, which resulted in the commission of a crime, then you should be punished for that. On the other hand, if you committed some acts, but you didn't intend for that to occur as defined by the law, or you didn't know that that was going to occur as defined by the law, and there's definitions of what intentional means and knowing means, so you'd have to figure out whether that applies or not, then the law takes the position that you shouldn't be punished for that because you didn't have control over the physical action that took place. As a result, you shouldn't be punished to the same extent as somebody who intended for that to occur and really set about a plan for that to occur. That's where the insanity comes in, because if the jury were to determine that the defendant, first of all, committed this crime, and the defendant was insane at the time that the crime was committed, there would actually be a verdict finding to that that says that. Then what happens is the defendant is committed to, it's actually the custody of the Department of Public Health and Safety, and is committed to their custody and placed in a facility, a mental health facility, until such time as sanity can be restored. The idea being, under the law, that we do impose punishment on people who should and ought to be responsible for their actions. If somebody is determined not to be responsible for their actions because of a mental defect or mental health issue or something of that nature, then the idea is to get them the treatment or the help that they need so that they can be restored to a better mental functioning.